Hey guys, Welsknight here, and I am bringing you today a video that I hoped I would never have to make. On Friday, I was hit with a fraudulent or erroneous Dmca takedown and copyright strike. Because copyright issues seem to be prevalent on YouTube, I want to take this opportunity to talk about them, especially since whenever copyright issues spring up on YouTube, there's a ton of misinformation that gets thrown around by YouTubers and people who do not really understand how copyright laws work or how they apply to YouTube. I want to be very clear, I am not a lawyer. However, I was a paralegal for over a decade, and I would venture a guess that my knowledge of the law is probably greater than that of the average YouTuber. But again, I am not a lawyer, and nothing I say within this video should be taken as legal advice. This video is going to be divided into two parts. First, we will talk about my current situation, and second, we will talk about copyright as it applies to YouTube in general, including fair use, licensing, valid and invalid claims, etc. I also want to note that this video is going to be very podcast-like. There's not going to be much happening on screen, so feel free to minimize the video and do something else while you listen. So, diving right in. On Friday, I was given a Dmca takedown notice and copyright strike by Game Show Network, or GSN for short, for my video Pixelmon Peridot Episode 5, The Ice Gym. GSN claims that my video included, and I quote, parts of full episode GSN's TV show Catch 21s. This is absolutely false. Furthermore, and this is the part that absolutely baffles me, this was a manual claim, which means somebody, a real person, actually watched the video and decided to issue the Dmca takedown and copyright strike. In almost 5 years of being a YouTuber, I have never included clips or even images of any TV show or movie into any of my videos. Unless Game Show Network, the TV network known for running reruns of old shows like Wheel of Fortune and Who Wants to Be a Millionaire, has somehow acquired the rights to Minecraft, or I suppose Pokemon, since in this case it was a Pixelmon video, which is a Pokemon Minecraft mod. They have absolutely no valid claim to anything contained within my video. All of the components of that video were either original works created by me, such as my commentary, or things which I have a license to use, such as Minecraft gameplay footage and the music. We'll talk more about licenses in the second half of this video. However, exercising some sort of greater wisdom that is obviously beyond my comprehension, somebody from GSN watched my video and saw fit to issue a Dmca takedown, removing my video from YouTube entirely and causing my account to receive a copyright strike. One of the significant problems with the current YouTube copyright system is that when someone issues a Dmca takedown, they are not required to point to specific timestamps or screenshots of what exactly it is they are claiming. Instead, the only information I have is the incredibly vague parts of full episode GSN's TV show Catch 21s. There's very little to go on from a legal standpoint. My only recourse is to contact GSN directly and request they retract their takedown by asking nicely, and I am 100% positive that I will absolutely receive a reply from a multi-million-dollar TV network which is a subsidiary of Sony and Warner, or to file a counterclaim, which I have already done. Now that I have filed a counterclaim, GSN has 10 business days to either file an actual lawsuit against me or to drop their claim. If they do not do anything by the end of 10 business days, the claim is automatically retracted. However, unless I decide to sue GSN for monetary damages in relation to their erroneous claim, they will receive zero penalty whatsoever for their actions. And to be entirely honest, the money involved in this in relation to this video is extremely minimal. This is a video that has already been out for several months and is part of a series that was relatively unpopular, so my expected revenue at this point from the video is like $1 or $2. It's not much. Given the time and legal fees involved with actually suing a multi-million-dollar company, it would be entirely stupid of me to do so. So, at this point, I will simply wait for a response to my counterclaim from GSN, or, more likely, for the claim to expire in 10 business days. As far as the channel is concerned, a single copyright strike is not really that big of a deal. I can still upload, I can still monetize my videos, I can still do everything else I was doing prior to all of this happening. However, if my account ever has 3 strikes on it, my YouTube channel, and with it my livelihood, gets deleted. This is why I have always been fairly careful when it comes to copyright considerations on YouTube. Thankfully, I don't foresee this specific situation really being an issue in the long run, as I am extremely confident that the claim is entirely false and the actual money involved is pretty much just pocket change. So now, let's move on to YouTube copyright stuff in more general terms. Copyright issues have plagued YouTubers for years. There are essentially 2 categories of copyright issues on YouTube that you will hear about: content ID matches or claims, and takedowns, which result in strikes. Those 2 categories are then further divided into valid and invalid or fraudulent claims. So first, let's talk about the difference between a copyright claim, or a content ID match, and a copyright strike, or DMCA takedown. Essentially, it boils down to the final result. It boils down to what actually happens to your channel when you get whichever one of those 2 it is. With a claim or content ID match, the video stays on YouTube, but the person or company issuing the claim receives all of the ad revenue for that video. Outside of the loss of the ad revenue for that specific video that's getting claimed, there's no real penalty for the YouTuber. Nothing really happens. No strike is issued to their account. Their channel's not going to be deleted regardless of how many times it happens. It's really not that big of a deal, other than the fact that you just lose any ad revenue from that one video. This is by far the most common type of copyright issue that YouTubers run into. On the other hand, a DMCA takedown is a much bigger issue, as it results in a strike being issued to the YouTuber. And as I said earlier in the video, if a YouTuber ever has 3 strikes on their account at a time, their channel is deleted, and they are not allowed to create a new channel in the future. YouTube has changed their policies regarding how strikes affect your account over the years, and strikes do go away after a certain amount of time has passed, usually 3 months. But, considering many YouTubers do this as a full-time job, it's still a pretty scary idea. Also, a DMCA takedown results in the video in question being completely removed from YouTube. So those are the 2 types of copyright claims. Now, let's talk about valid versus invalid and fraudulent claims. There are so many misconceptions regarding what is and is not a valid claim, often repeated and spread around as gospel by people who have no idea what they're actually talking about. A valid claim is simply that, a claim which is valid, in which the claimant actually owns the rights to issue a claim for whatever it is they're claiming, whether that be a song, an image, a movie clip, whatever. We'll call these works from here on out. When I say owns the rights to issue a claim, that does not necessarily mean that the original creator of the work has to be the one issuing a claim for it in order for the claim to be valid. A musician, for example, could pass that responsibility on to a record label, and the record label could issue a valid claim for the musician's songs being used without permission. An invalid claim, however, is the opposite. A claim in which the person or company issuing the claim does not actually have a valid legal claim to whatever it is they are claiming. For example, Game Show Network does not own the rights to Minecraft and therefore cannot say, we own Minecraft and you're not allowed to use it, and therefore they cannot issue a valid legal claim for Minecraft gameplay footage. Now, let's get into some common misconceptions regarding copyright. First of all created works are copyrighted, unless the copyright has expired and the work has entered into public domain. That's going to be stuff like Bach and Mozart. If a YouTuber has permission to use a created work, that is called a license. A license does not necessarily have to be in writing, although that is preferred, nor does it always have to be purchased. A license basically states what and how you can use someone else's creative works in your own content. License is the ability to use somebody else's stuff. Copyright is the ownership of something, okay? So, whenever someone creates something, they get to choose what type of license it falls under. Most of the works I use in my videos are licensed under a type of license called Creative Commons Attribution, which basically translates to, you can use it for whatever you want, as long as you give me credit. However, that does not mean I hold the copyright to those works. I cannot claim that I created the work and that it is mine. I simply have a license or permission to use it. In most cases, as it relates to YouTube, licenses are either purchased individually, such as my outro song, for example, or given in a blanket statement on an artist's website. It is important to note that an artist cannot issue a valid license to use something which they do not have the proper rights to. Recently, my friend Mumbo Jumbo had some significant copyright issues as a result of this. Basically, what happened in his situation was that he was using a song which he thought he had a valid license to use, but it turned out that the artist who made the song essentially took someone else's song, reworked it, and told people they could use it. That would basically be like, it would be like me taking AC/DC's Back in Black, cutting off the second half, speeding it up a little bit, and then telling people, I now own Back in Black, and you can use it however you want. AC/DC or their record label could still claim my song, wherever it is used, and their claim would be entirely valid, as they never gave me permission to use Back in Black or to redistribute it as my own. That is not how copyright law works. If I don't have a proper license to do something, like remix a song and then redistribute it for other people to use, I cannot legally do that. As a result, Mumbo was put in the unfortunate position of having valid claims against most of his videos, even though he thought he had been doing the right thing. Essentially, the person who remixed the song that he was using gave Mumbo a license that simply wasn't theirs to give in the first place. Now, let's dive into the biggest misconception on YouTube: fair use. Fair use is basically a legal doctrine which provides for certain exceptions to the way copyright laws usually work. It's based on a combination of 4 factors. 1. The purpose and character of the use, including whether such use is of commercial nature or is for non-profit educational purposes. 2. The nature of the copyrighted work. 3. The amount and substantiality of the portion used in relation to the copyrighted work as a whole. And 4. The effect of the use upon the potential market for or value of the copyrighted work. Now, that's a lot of words, and most of them were in legalese. So, let me break them down for you. First, the purpose and character of the use, including whether such use is of commercial nature or is for nonprofit educational purposes. Basically, this part talks about what the copyrighted work, that is, whatever's being claimed, is being used for. For example, whether it's being used in a commercial for a car dealership, or in a monetized YouTube video, or on the flip side, if it's being used in a classroom setting, or for critique of the copyrighted work, such as in a review. Commercial uses, meaning uses that you're getting paid for, which includes monetized YouTube videos, are less likely to be considered to fall under fair use. Number 2, the nature of the copyrighted work. Essentially, this revolves around what type of work the copyrighted work or the claimed work is. Something created entirely from scratch, so something completely out of somebody else's imagination, is less likely to fall under fair use than something based on facts, such as a documentary or a news article. Number 3, the amount and substantiality of the portion used in relation to the copyrighted work as a whole. This covers the amount of the copyrighted or claimed work that is actually being used. Generally, the less you use, the more likely that your copying will be excused as fair use. However, that is not always the case, and it is also important to note that this does not say in relation to the final work as a whole. So basically, one thing I see a lot on YouTube is people say, how come if you use 30 seconds of a song, they get to claim the entire 30-minute video? That is not part of fair use. It doesn't matter how long the final video is. All that matters is how much of the copyrighted work you actually used in your video. So basically, if you use 5 seconds of a 3-minute song, that is far more likely to fall under fair use than using all 3 minutes of a 3-minute song. I also want to add here that there is no amount of time that is okay. There's not like a rule that says if you use less than 30 seconds of a thing, that's fine. That does not exist. That is a rumor and a completely false piece of information that often gets spread around. There is no 30-second rule. There is no minute rule. There is no 15-second rule. Such a thing does not exist. So please do not spread that around ever, because it is entirely false. And finally, number 4, the effect of the use upon the potential market for or value of the copyrighted work. This comes down to how the final product will affect the original copyrighted work from a monetary standpoint. If you are putting a song into your video that people would normally have to pay to listen to, that is less likely to fall under fair use because people can simply watch your video instead of buying the song. Another example of this would be many reaction videos. Why bother watching the original video once you've seen the reaction video? And now here's the important part. Fair use is a defense to copyright lawsuits, and whether the use of a work falls under fair use can only be determined by a court of law. Something is not automatically fair use because a YouTuber says so. And just because the use of a work meets one or more of the factors that we just covered does not mean the use actually falls under fair use. Fair use is a complex legal defense in which a judge analyzes the 4 factors and reaches a final yes or no decision. YouTubers cannot determine fair use. YouTube cannot determine fair use. You cannot determine fair use. Only a judge in a court of law can determine fair use. So when a YouTuber says, this is obviously fair use and this is a bogus claim, they might end up being correct in the end, but only a court of law can actually determine that. And no amount of social media outcry is going to change it. And in many cases, YouTubers misunderstand that fair use is a combination of multiple different factors, and their videos do not automatically fall under fair use even if they meet some of those factors. Another thing I want to address is that YouTube is required by law to handle copyright issues in a certain way. A lot of people are very quick to blame YouTube about how they handle copyright, and that they tend to always take the company's side and they're always out to get the YouTubers. And while I certainly agree that YouTube's copyright systems could be improved, especially like we talked about before with requiring claimants to be far more specific about what it is they're actually claiming, for example, you have to realize that YouTube has certain metrics and things that they have to do in order to essentially keep their business alive. They have what's called a safe harbor protection, which means YouTube is not directly held responsible for every single copyright issue that happens on their platform. If they lose that protection, then YouTube itself can be held responsible every time some idiot decides to re-upload an episode of Friends or something. And obviously that is not a sustainable business model when you allow people to upload basically whatever they want, whenever they want, and sort it out afterwards. So keep that in mind. YouTube has certain things that they have to do in order to keep their safe harbor protection and to essentially keep YouTube as a platform around. All right. This video has already gone on significantly longer than I originally planned, but I hope you got something out of it. If you learned something, please leave a like and share it. The next time you see these misconceptions we talked about being spread, I will try to answer any other questions you might have in the comments down below. With that, thanks for watching, and I'll see you in the next one.